All right. So, you know that feeling when you open your mailbox and there's like official-looking paperwork staring back at you?
Yeah.
Yeah, today we're tackling one of those fun little life events, that 60-day notice to vacate. We've got this article here, 60-day notice to vacate from landlord in California. And trust me, by the time we're done, you'll be fluent in landlordese.
It's true. These notices, they can feel like a foreign language sometimes. But like with any language, once you understand the grammar, so to speak, it's way less intimidating.
Totally. And the good news is getting one of these notices isn't a guaranteed eviction. It's more like round one of a very specific legal process, wouldn't you say?
Absolutely. And like with any good boxing match, knowing the rules is half the battle.
Love that analogy. Speaking of rules, one thing this article highlights right away is that California is known for being pretty tenant-friendly. They even mention this case where a landlord tried to evict someone over a super technical detail about how the notice was delivered.
Oh, I think I remember that one. That's the one where the court actually sided with the tenant, right?
Yep. The judge basically said the landlord hadn't crossed their T's and dotted their I's properly, so the whole thing got tossed out.
It's a good reminder for everyone out there. Landlords don't have free rein. The law is designed to protect both sides.
Music to my ears.
Mm-hmm.
Okay, so the article dives into this whole thing about the difference between a 30-day and a 60-day notice. What's the deal with that? Is it just up to the landlord to pick which one they feel like using?
Not at all. It all comes down to how long you've been living in the unit.
Okay, so like if I just moved in last month versus if I've been there for 5 years, it's different.
Exactly. If you've been there for a year or more, California law says it's got to be a 60-day notice. Anything less than that, you're probably still within that initial lease term. So 30 days is standard.
Gotcha. That makes sense. Now, the article lists a bunch of different reasons why a landlord might give you one of these notices. Selling the property, wanting to move in themselves, even just wanting to do like a major remodel. Seems like they've got a lot of leeway there now.
You're right. The reasons can be all over the map. But there's a key phrase to keep in mind here. Just cause eviction.
Okay, so it's not just a free-for-all. They can't just kick you out because they're feeling spontaneous.
Exactly. They need a legally valid reason, and even then, they've got to follow a specific process.
Which is probably where knowing your city's specific rules on just cause comes in handy, right? Like on top of the state law, there might be even more local regulations.
You got it. It's like layers of protection.
Okay, so let's say the landlord does have a valid reason, and they've hit you with this official 60-day notice. What happens next? Do you just start packing your bags? Whoa, hold your horses there, buckaroo! Before you start disassembling your entire life, let's talk about what you can do if you get hit with one of these notices.
That's right, because you actually have more wiggle room than you might think.
That's the kind of talk I like to hear. Everyone loves a good sticking it to the man story. Right. But seriously, this article does a great job of, keeping it real. Getting one of these notices can feel intimidating.
No doubt.
But they also make it super clear that you, as the tenant, you've got options, even if it feels like, a worst-case scenario.
It's all about knowing how to advocate for yourself.
Preach. And a big part of that is understanding this whole thing about warranty of habitability.
Ah, yes, the warranty of habitability.
Now, I'll admit that sounds kind of like something you'd hear a lawyer say on TV right now. But it's actually a pretty straightforward concept when you break it down.
It is. So what they're really saying is that, your landlord, they've still got to hold up their end of the bargain, even during that notice period. We're talking, making sure the place is livable, functioning heat, hot water, no, giant leaks in the roof, the basics.
Okay, so even if they're planning to, gut the place in a few months, they can't just ignore a busted pipe or black mold situation.
Nope. And this, my friend, is where that meticulous documentation the article keeps harping on comes in handy.
Yes. Receipts, photos, the whole shebang, always CYA. Right?
Exactly. Got a leaky faucet, snap a picture, send an email to your landlord about it, and most importantly, keep a record of their response.
It's like building your evidence file, just in case things go south.
Precisely.
Okay, so speaking of things going south, the article gives this really wild example of something called waiver of notice.
Oh, yeah, that's a good...
So apparently there was this case where a landlord tried to evict a tenant, right? They'd sent the 60-day notice, everything seemed official, but then, get this, the tenant argued that the landlord had actually voided their own notice.
By accident.
Well, by accidentally cashing a rent check that was dated after the tenant was supposed to be out.
Oh, wow. Talk about shooting yourself in the foot.
I know, right? But here's the kicker. The court actually sided with the tenant.
No way.
It just shows that even though this is serious legal stuff, these situations can hinge on, like, the tiniest details.
The devil is in the details, as they say.
Okay, so let's say the landlord hasn't made any goofy missteps. And the notice, like, seems legit. Does that mean game over? Do you have to pack up and go?
Not necessarily. Remember what we said about options?
Oh, right.
The article is very clear on this.
Yeah.
You have every right to contest the notice.
Okay, so challenge it head on.
Exactly. You can basically say, hey, I don't think this is valid, especially if you think your landlord didn't follow the proper procedures.
So, like, if the dates are wrong or they didn't deliver it properly.
Exactly. Or if you think the eviction is what's called retaliatory.
Ooh, retaliatory eviction. That's another one of those legal terms that sounds kind of scary.
It's just a fancy way of saying that the landlord can't try to kick you out because you've been, standing up for yourself as a tenant.
So, like, if I've been requesting repairs or I contacted the city about a code violation, they can't just use this notice as payback.
You got it. California law is very strict about that kind of thing.
Okay, so we've talked about challenging the notice, but what if, even after all that, the landlord is still set on showing you the door? That's gotta feel like, what do you do then?
Well, it's definitely not ideal, right? But even if it goes that far, like even if a judge ultimately sides with the landlord, you still might have some wiggle room.
So it's not like they can just show up with a moving truck the day after the court case.
Exactly. A lot of times, a tenant can actually negotiate for more time to find a new place.
Oh, interesting.
Or even work out some kind of deal with the landlord. Maybe to cover some moving expenses. It's worth a shot.
Right. I always say everything's negotiable.
Exactly. The most important thing is to stay calm, stay informed, and remember, you have rights throughout this whole process.
And hey, even if you never actually have to go to court, like even if this never happens to you, this knowledge is still power, right?
Absolutely. It's like the more you know, the better prepared you are for, well, whatever life throws at you.
For sure. Now, I know we've covered a ton of ground here in this deep dive, but if there's one thing I really want our listeners to take away from this whole conversation, it's that you don't have to go through this alone. Like, there are people out there who can help.
100%. The article mentions a bunch of resources for tenants, like legal aid organizations, housing rights groups, all sorts of stuff.
Right. They're like your backup squad, right?
Exactly. There are tenants' rights organizations all over California that offer free legal advice, support, you name it. And on top of that, lots of cities actually have their own housing departments that can be super helpful.
It's like having a whole team of experts in your corner ready to fight the good fight. So before we wrap things up here, any final words of wisdom for our listeners out there? Anyone who might be staring down the barrel of a 60-day notice right now, what should they do?
First things first, don't panic. Seriously, take a deep breath. Maybe grab yourself a calming beverage. You got this. Then, get that paperwork organized, get familiar with your rights, and don't be afraid to reach out for help if you need it.
Could have said it better myself. Knowledge is power, folks, and now you've got the knowledge you need to handle this situation with confidence.
And remember, even if you're not facing a 60-day notice right this second, this stuff is still good to know.
Yeah.
Like knowing your rights as a tenant, it's like a superpower you can use in all sorts of situations.
It's truth. Whether you're renewing a lease, dealing with repairs, or, even getting one of those pesky notices. Well said. Thanks. And on that note, a huge thank you to you for joining us for this deep dive into the wild world of 60-day notices in California. We hope you found it informative, empowering, and maybe even, a little bit entertaining. And hey, if you know someone who might find this helpful, spread the love. Share this episode with a friend.
Always good to pay it forward.
Now, this whole conversation got me thinking, what are some things that tenants and landlords could be doing to, make these kinds of situations less stressful for everyone involved? Maybe it's all about better communication or having clearer expectations right from the start. It's definitely something to chew on. Until next time, stay curious out there.
Call now, 714-442-9741. Thank you.